session will be is called See You in Court to Trump, and it will be about the efforts from the civil society organizations in the US, particularly the American Civil Liberties Union, and in questioning some of the measures and politics by Trump during this first year of his presidency. Donald Trump was elected the 45th president of the United States on November 8th, almost precisely a year ago, 2016. He had been a real estate developer, entrepreneur, and host of the NBC reality show, The Apprentice. Now, he would become the leader of the free world with enormous powers in his hands. He had run a campaign where he promised to make America great again, and some of the protectionist measures he said he would set out to do was to build a wall against Mexico in order to stop immigrants from entering the US. He would forcibly remove 11 million undocumented immigrants, ban the entry of Muslims into the US and aggressively surveil them, and of course withdraw from the Paris Agreement and tighten import restrictions. And from a human rights perspective, many of the measures that were supposed to make America great again were devastating for human rights, and reactions from US-based organizations were strong and unafraid. The American Civil Liberties Union soon started a campaign called See You in Court Trump, in which it, I think even before he was elected, in which it pledged to closely follow the actions of the president and sue when measures violating human rights and the US constitutions were taken. And now the fight is on. And in the opening months of Trump's presidency, the ACLU reports that he has undermined reproductive rights, used religion to discriminate against LGBT people and religious minorities, trampled on the rights of immigrants, worked to deepen the racial inequities at the heart of the US criminal justice system. ACLU warns that Trump's politics can give a lasting damage on American democracy. And as a reply, quite recently, the Ministry of Justice more or less declared war on the ACLU attorneys. I am very happy that one of these attorneys, very unafraid, attorneys from the ACLU is here with us today, Esha Bhandari, who will both help us understand the separation of powers in the Constitution and the important role the Constitution plays in politics and laws in the US, and then present some of the cases she has been working on, and the ACLU is now running in courts due to the Trump administration politics. So, without further ado, I'll give the floor to Esha Bhandari from the ACLU.
Thank you very much, Anna. Thank you very much. I'm very happy to be here. I'm a staff attorney in the ACLU's Speech, Privacy, and Technology project, where I litigate cases involving free speech, academic freedom, and the right to privacy. But I am within the ACLU's National Legal Department in New York, where we have a wide variety of projects, including Immigrants' Rights Project, National Security Project, LGBT Project, Reproductive Freedom Project, and many others. So much of what I'm going to discuss will be the work of my colleagues in the National Legal Department, as well as one of the cases that I've been working on. As Anna mentioned, we've spent a very busy year in court using litigation as a strategy to fight back against the Trump administration's unconstitutional policies. And we've been doing this at the same time as we've been seeking to advance long-running goals to protect civil rights and civil liberties, involving challenges to policies that have crossed administrations. So the work that we were doing under the Obama administration, for example, involving accountability measures in the national security realm, for example, that work continues, and that has not ended. So our challenge is really continuing our long-running goals while also responding to new policies that the Trump administration has put forward. So my goal is to describe a few of the key lawsuits that we've brought, but before I do that, I'll give a brief overview of the constitutional provisions that are most often invoked in litigation in the United States. We have a Bill of Rights in the Constitution, and there are certain key amendments to the Constitution that are considered part of the Bill of Rights, which are most often invoked in the type of litigation that the ACLU and other organizations committed to civil rights and civil liberties use. Some of them I imagine are very familiar with. There is the US Constitution's First Amendment, which protects freedom of speech and freedom of assembly, and also prohibits the establishment of religion on the part of the state. So this is a critical part of our litigation efforts, and as I will mention, it has played a role in the travel ban litigation as well. Another frequently invoked amendment is the Fourth Amendment to the US Constitution. This is often what is invoked in privacy cases. It's the guarantee of being free of unreasonable searches and seizures. It's the guarantee that the government must get a warrant in most cases involving privacy. And so the Fourth Amendment protection is invoked in many instances where we have violations of privacy rights, including a challenge to warrantless border device searches, which I will discuss later. The Fifth Amendment is also commonly invoked in litigation. The Fifth Amendment protects due process of law, and that has two components. It's both a procedural protection, meaning that the government cannot deprive someone of life or liberty without providing adequate procedural protections, which means in most cases the opportunity to contest the government action before a neutral decision maker. And there's also a substantive component to due process of law. It provides a backstop on the type of deprivations that a government can never do. So for example, a prohibition against torture, for example, might sound in a substantive due process protection. So there's two components there. And then lastly is the 14th Amendment, which is the guarantee of equal protection under the law. And that amendment is often seen in cases involving discrimination and is usually invoked in instances where there is some either racial discrimination, but it may not be that. It could be gender-based discrimination, discrimination on the basis of sexual orientation or gender identity as well. So those are the amendments that are most commonly invoked in the type of constitutional litigation that I'm talking about. There have been many challenges to Trump administration policies in the first year. Some of them have involved challenges that the president is exceeding his authority as a statutory matter, because we have in the US the system of tripartite government, the executive branch, the legislative branch, and the judicial branch. And much of what the Trump administration has done this year has been done through executive order, meaning the president signs an executive order directing federal officials to do something or requiring certain actions. And in many cases, there have been challenges to those executive orders as exceeding his authority under the statutes, under the laws that Congress has passed. So I'm not going to discuss that too much, but that's just a thing to keep in mind that, given Congress's role in passing laws, there are also limits on what a president can unilaterally do. And so if there is a claim that the president has in effect rewritten a law that the Congress passed, that would create a separate issue. But the focus that I'm going to bring today is on constitutional challenges, meaning regardless of whether the policy is done through a statute or through an executive action, such as an executive order, that government policy or action violates the US Constitution. So I'll just give a few highlights before we open it up for questions. Obviously, one big area of litigation that has captured, I think, a lot of attention in the United States and around the world is the travel ban litigation. And this litigation has been ongoing since very early in the Trump administration. There have been 3 iterations of the travel ban so far. The first was signed by the president in January. It placed an immediate ban on the entry of individuals from 7 Muslim-majority countries, and it created an outcry. And I'm sure many of you have seen the photos of the airport protests that happened throughout the country. There was no notice given, no warning. Civil society had to react quickly. I will never forget that weekend. It was it was a very difficult weekend, but it really showed the power of citizen protest, of individual protest, of the not just the immigrants' rights community coming together, but of a much wider group of people who really protested. And I think that the protests and the quick reaction by the public to the first travel ban was a critical part of the legal battles that followed. I think one thing we've really seen this year is while we are in court litigating, there is a lot of activism happening. There's a lot of protest, a lot of engagement with elected officials, and this undoubtedly has an influence on the course of litigation. It affects the conversation in the media. It affects how judges think of cases, what their initial impressions are. So I think the travel ban litigation is a perfect example of how the uprising went hand in hand with the litigation. But the litigation was a critical part of that first weekend where there was an immediate lawsuit. And again, because this ban was put in place without warning, you had people who are permanent residents of the United States being stopped at airports, and in some cases being told that they had to go on planes back to where they had come from. So individuals with green cards, people who have lived in the United States, they are permanent residents, and there was just a lot of chaos and confusion and no guidance for officials at the airport. So there were some really egregious instances of people coming back home to the United States being detained or turned away. So that led to the sense of urgency. A team of lawyers, including from the ACLU, working overnight. The travel ban came down on Friday, and on Saturday evening, we found a judge in the courtroom in the federal district courthouse in Brooklyn, and the judge heard arguments Saturday night within 24 hours and put the first immediate stay, meaning that the government couldn't implement the travel ban. That was the first action. And the stay was put in place while the merits of the litigation could continue. That was the first, I think, big litigation win in the Trump administration, was just being able to go into court and being able to protect the very immediate rights of people who are being detained at airports. That first iteration of the travel ban was replaced in March. So even while litigation on the merits against that ban was going in place, while it was stayed and the administration could not put it into effect, in March there was a new travel ban signed, and it exempted lawful permanent residents, it exempted green card holders, and it took Iraq off the list of countries. But nonetheless, it operated as a ban, and we sued again. And there were multiple lawsuits. I want to emphasize it's not just the ACLU. Many civil society groups have sued, and including states. So one of the major cases in the travel ban litigation has been Hawaii v. Trump, because the state of Hawaii has also been suing. And we've seen in this era of litigation against Trump policies that many states and localities have been very energized, and they also have interests. And so the state of Hawaii, for example, has invoked the interests of its residents and the people in Hawaii who will be affected by the travel ban, who will not be able to have their colleagues or their students or their family members come to the United States. So the second version of the travel ban was also enjoined, meaning that the Trump administration was not able to put it into effect, that the court said, while the litigation proceeds on the merits, you cannot implement this. And the posture of what we call a preliminary injunction means that because of the equities, because the harm is so great on the side of the people whose rights are invoked, and the likelihood of success is on their side, that the law is enjoined. And there were various rationales, but I'll focus on what the Fourth Circuit Court of Appeals said, which is a court of appeals that's based in Richmond, Virginia. And that Court of Appeals said that the evidence of the animus driving the travel ban, that it was motivated by a desire to discriminate against Muslims, that is what rendered it unconstitutional, and that you had to look at the motive behind the ban, which is the argument that we have been making against every iteration of the Muslim ban. That President Trump has been very clear, in fact, that it's what he terms a Muslim ban, and has been very open about the motivation behind it, and has said very clearly that even as the language of the travel bans changes from January to March, and we now have a third version, that the desire, what he is trying to accomplish with that, hasn't changed, and we're asking the courts to take that motivation seriously and to recognize that that is an impermissible motivation under the Constitution. Now, the second version of the travel ban was accepted for review by the Supreme Court. The Supreme Court granted cert, which is the procedure by which the Supreme Court accepts cases to review. And it was set to be argued this fall, but it has been removed from the calendar, and the Supreme Court is not going to hear that case anymore because of what is known as the mootness doctrine. Essentially, because the administration replaced the second travel ban with Travel Ban 3.0, the Supreme Court decided not to hear arguments and not to address the lawfulness of the second travel ban because it's no longer in effect. And this is because by its terms, the second travel ban was supposed to last for 90 days. And when that period expired, the administration replaced it with a third one. So even though, we've always argued that the motivation behind each of the travel bans is the same, nonetheless, we're now back litigating in the first instance Travel Ban 3.0, as we call it. We went back to the district court, got again an injunction against Travel Ban 3.0, and this case will now have to make its way through the courts again, and we will see if Travel Ban 3.0 eventually is heard by the Supreme Court. So it's been a very busy year of litigation against that, and as I mentioned, it's been us, but it's been other civil society groups and some states. There's been no shortage of litigation on the travel ban. Another case that I want to mention briefly is a lawsuit that we brought this year challenging the Trump administration's continuing policy, which dates back from previous administrations, of searching travelers' devices at the international border without a warrant. And this is our case. It's a challenge known as Al-Assad v. Duke, which we've brought on behalf of 11 travelers, 10 U.S. citizens, and 1 lawful permanent resident of the United States, who had their devices searched, their phones or laptops, at the U.S. border when they were returning home, without any basis for the search taking place. And the government asserts the authority to conduct these sorts of searches without any individualized suspicion. And our concern is that this is a grave threat, not only to privacy rights, given the immense amount of personal information that's contained in people's phones, but that it'll have a real impact on freedom of speech, freedom of expression worldwide. If this type of suspicionless search at borders becomes the norm, it will, the concern is that other countries will adopt the same policy. It will inhibit freedom of movement. It will particularly inhibit dissidents, activists, others who will self-censor because they'll be afraid that when they travel or even when they return home to their own country, that the government will be able to look through limitless amounts of information about their lives and their contacts. So this is a challenge where we've raised 2 claims: a Fourth Amendment claim, which, as I mentioned, is the protection against unreasonable searches and seizures, and a First Amendment claim that this affects the freedom of speech, freedom of assembly, because it permits the government to get all of this information about people's contacts and activities. And then I'll move to a different realm of challenges that we've done this year. The attack on reproductive freedom, which is something that we anticipated, has come in multiple fronts. And most recently, there has been a high-profile case that has, again, gotten the attention not only of courts, we've been in court, but it has gotten a lot of civil society activism going hand in hand, just as with the travel ban. And this is the Jane Doe case. Jane Doe is a minor being held in detention. She is an undocumented immigrant. She fled her home country and came to the United States, and as is the US government practice with so-called unaccompanied minors, she is being detained. Jane Doe was seeking to get an abortion. She was pregnant, and because she was being held in not a government facility, but the government has contractors who do the immigration detention. So she was being held in a contractor's facility, and the government office, known as the Office of Refugee Resettlement, the head of that office was prohibiting Jane Doe from leaving the facility to get an abortion that she wanted. So she had, she had already made the decision, and under Texas law, where she was being held in Texas, under Texas law, if you're a minor and you cannot get parental consent, and in her case, she had fled an abusive situation and did not want to tell her parents. Under Texas law, you have to get permission from a judge, and she had gotten that permission. So she had complied with Texas law requirements, but nonetheless, it was the Federal Office of Refugee Resettlement that wasn't allowing her to leave to go to the appointment. So we sued, and in U.S. law, her right to go to the clinic and get an abortion is clear. And so this was really an unprecedented attack. And the heart of the government's argument was two claims. One, that they weren't imposing an undue burden on Jane Doe's right to get an abortion because she was free to leave the country. If she gave up her claims to remain in the United States and went back to where she came from, she had that option. Of course, one of the judges who wrote an opinion in the ultimate in the case said that you can't condition someone's exercise of their rights on them giving up other legal rights. So it's no answer to say that simply because you can give up your legal rights to stay in the United States and her arguments to be allowed to remain, that can't be a condition for exercising other rights. That would flip everything upside down. And then the second argument the government was making, which is very troubling, was that they are not required to facilitate Jane Doe getting an abortion. Now, the government's argument that it would facilitate was simply that it would not stand in her way when she went to her appointment. She's clearly permitted to go to other healthcare appointments. The contractors allow the immigrants who are detained to attend other medical appointments. It was simply this particular medical appointment that the government did not want her to go to, and so their argument was that by not standing in the way, we will be facilitating this. The government's not required to pay anything in this case. The cost would have been borne by someone else. The contractor was willing to do whatever paperwork is required to let Jane Doe appear at her appointment. So really the government's argument was just that it's in any way being required to, in effect, follow the law by allowing Jane Doe to leave, that this becomes facilitation. Which is, as I mentioned, a troubling argument because it would mean that government involvement in a whole host of issues that it disagrees with, where people's rights are at stake, could be converted into an argument of facilitation. Anytime the government is required in whatever way to be involved in effectuating someone's rights, it could simply claim that this is a facilitation of something we disagree with, and that can't be the law. So the D.C. Circuit Court of Appeals, which is the federal court of appeals based out of D.C., sitting en banc, meaning every active judge on that court, voted 6-3 that this was that Jane Doe had to be permitted to go to her appointment. That was the most critical ruling because, again, under Texas law, Jane Doe only had a limited amount of time to get an abortion, after which Texas law would not have permitted it anymore. So the D.C. Circuit was looking at the question of, in the balance of irreparable harm, the harm to Jane Doe versus the harm to the government, and it held that the district court, the underlying court, had been correct in issuing an injunction saying that the government has to allow Jane Doe to leave for her appointment. So this was, again, as I mentioned, a very high-profile case. It got a lot of attention, and I think has, caused a lot of people to worry about the state of reproductive freedom in the United States if this is representative of what the administration's approach is going to be. And then I think I'll mention one last case, which we sued the administration over, but which ultimately was not resolved in court. This is the case of another undocumented immigrant, Rosa Maria, who's 10 years old. She has cerebral palsy, and she was on her way to the hospital for surgery in an ambulance. And to do so, she had to go through a checkpoint. And in many parts of the country, the government has set up immigration checkpoints. Even though it's interior to the United States, individuals still go through these checkpoints where they are asked their immigration status. And we have challenged these checkpoints in the past, for obvious reasons that they require undocumented individuals to submit to this search without any suspicion whatsoever. They require all individuals. It's anyone going through the checkpoint. But nonetheless, at the checkpoint, when the government officials found out that Rosa Maria, the 10-year-old, is undocumented, they followed the ambulance to the hospital. They stayed by the hospital room, and when Rosa Maria was out of surgery, they arrested her, and they took her into detention. It's a really sad and horrible situation. Rosa Maria was accompanied by a relative because her parents are undocumented, but Rosa Maria has always lived with her parents. And by taking her into custody, of course, she was deprived of going home and recovering with her family. So we sued. There were many claims that we made, including statutory and constitutional claims. And one of the constitutional arguments was a Fifth Amendment argument that Rosa Maria's parents had effectively been separated from their daughter or denied their parental rights with no procedure whatsoever, that the government had in effect removed their daughter from their custody. We immediately sued, and I'm happy to say that shortly after we sued, the government released Rosa Maria, and she's back home with her parents. And that was another instance of a huge public outcry from across the country, and including on the part of elected officials. And I think that public attention supplemented and supported the litigation work. They went hand in hand to really show the reach of these policies and just how inconceivable it is that immigration enforcement actions are now being taken, targeting 10-year-olds, getting medically necessary surgery, and arresting children in hospitals, which is really unprecedented. So I'll leave it there.
Okay. Thank you, Esha. I thought we could just follow up on a few questions regarding the Constitution and the executive powers. What do you think, or maybe it's a very understandable answer to this, but why do you think the Trump administration tends to use the executive order to implement the politics and not go through Congress? Is that because they know they won't get the support they need, or is it just that they feel that they need to sort of realize their promises from before the election? What are the reasons, you think?
So I don't know the actual motives, but certainly it is faster, and as we've seen in this year, legislation is difficult. You have to go through both houses of Congress, you have to get the majority vote, and in some instances you have to overcome a potential filibuster, meaning you need a supermajority vote, and then, only then can that policy come to the president's desk for signature. And that is a difficult and long process. Certainly executive orders can be done quickly and only involve the president. But as I mentioned, in the system of separation of powers, while the president has what's known as the Article 2 power, the power of the executive to implement the laws and to carry them out, and that necessarily comes with it some leeway, there are real questions about how much the executive power extends. And as I mentioned, particularly when the executive power is contradicting a law that Congress has passed, that's when you've got clear conflict. But in some cases, you have executive power that's simply acting in the absence of Congress because Congress is taking too long, or Congress maybe would disagree if they acted. And so we've certainly seen a lot of executive orders this year.
We have a discussion in Sweden right now with that. We tend to think that our constitution is quite weak because it's not, you can change it actually after just one election and then an extra election, and then perhaps all the rights and democracy, the rules that are in our constitution can be changed very quickly. What about the American Constitution? Are there non-derogable rights in it? Are they changeable? And in particular when it comes to the protection of individual rights. Can you tell us a bit about that?
Yes, so as I mentioned, the Bill of Rights actually refers to the amendments. So, by definition, they were amendments to the original Constitution. But the process of amending the Constitution is difficult, and it would involve a very lengthy process. It would, at the end of the day, even if there was an agreement on what the amendments would be, you'd have to get ratification from the states and go through a process. So, for the time being, in effect, we've got the Bill of Rights, and that's what we have to work with. And with respect to that, the judicial branch really has the final say in what the meaning of those are. That's the way the system of separation of powers works. So, when you have a challenge saying that this policy violates, let's say, the First Amendment guarantees, and the Supreme Court says, yes, the First Amendment does not permit this, the U.S. Congress cannot simply override that, for example. They cannot pass a law that says, we want this policy in effect anyway, and so we decide that it doesn't violate the First Amendment. Once the judicial branch has said that is the law. That's not to say that the other branches don't have a role in constitutional considerations, and one of the things that we often say is Congress and the executive branch are required to think of the Constitution every time they act, because not everything can be adjudicated in court for a variety of reasons. There are all kinds of procedural limitations on who can sue in the first place, who has standing to sue. That's a limiting doctrine that says people injured by a policy are able to go into court and sue, but we don't have this sort of general public interest litigation kind of standard that you see in other countries where anyone could sue over anything. So there's procedural hurdles to being in court. There's procedural hurdles to getting ultimate relief. And so because everything cannot be ultimately adjudicated in court, it's really critical that the political branches, when they're putting in place policies, also do their independent constitutional analysis and take that responsibility seriously. Every president takes an oath to uphold the Constitution, and in an ideal world, that means that the president also considers the constitutionality of policies rather than simply saying, I will do what I want to do, and I will leave it to the courts to decide.
So we'll see, is there a difference? Because at least from the outside, it seems like there's a difference between Trump and previous presidents, even Bush and Clinton, in actually abiding by the law, in the sense, in actually looking at what consequences their suggestions and the measures have on the Constitution, and if it's in line with the Constitution or not. Do you think there's a difference with the politics that Trump is having and the other previous presidents? Can you see a difference?
I can't speak to whether there's any difference. I think one thing that is critical, even as we've had this campaign this year, is to emphasize that a lot of the work has continued across administration. So I'll give one example, is challenges to immigration policies. We had many challenges to Obama administration immigration policies, including immigration detention, which is a critical area that there has been continuity within administrations on, and the denial of lawyers, the denial of counsel to immigrants in detention. So Well, I'm not sure that I'm in the best position to make a comparison in terms of who cares more or respects this more. I do want to emphasize that a lot of what we're seeing now is a continuation, maybe an expansion of existing policies that we've been challenging for a long time.
Mm-hmm. I just want to say, if there's anyone who wants to ask the questions to Esha, please feel free. I think I will be able to see if you wave your arm. And in relation to that, it seems like also the measures that are taken and decisions that are taken from the Trump administration are in a way in urgency, in a way that they're very, seems to not be completely well written or whatever, but also something that seems to be. So with the Jane Doe case, for example, there was an urgency because of the time being, after a couple of weeks she wouldn't be able to have an abortion, for example, and that seemed to be deliberately postponed by the Ministry of Justice, and there seems to be a very antagonistic response from the government, both to the litigations, but also an urgency in the policies. It's a little bit related to what I asked before, but can you see is that again something that it's just that they want to push through legislation as soon as possible and make a change as quickly as possible? And a follow-up question to that, is that also why you talk about that the democracy in the United States is actually in danger because of the urgency and of these decisions, because it can change quickly if they're not challenged, do you think?
Yeah, that's a good question, and I'll give two other examples. One is, of course, the travel ban. With the first one, came down with almost no notice and no advance warning of what the content would be, and again, as I mentioned, within hours of it coming down, you have people coming home to the United States, being detained at the airports. So that kind of rush and urgency that I think took us aback, and of course meant we had to rush into court. And then the other example I'll give is the ban on service in the military by transgender individuals, which was announced on Twitter with no warning. Again, no clarity. Does it apply immediately? Does this mean people who are currently serving will lose their jobs, their livelihoods? Again, this sort of abruptness and the urgency, which I think has one, kept the lawyers very busy all year, and sort of trying to prepare as much as we can in anticipation of policies that we think are coming, but knowing that sometimes these policies are announced with no warning whatsoever, and we have to be ready to go to court. And then I think it has kept the protest movement quite engaged. So I think that there has been a lot of immediate engagement. So again, with the travel ban, just the a lot of my friends and I were joking that we can't remember the last time that people willingly went to JFK on a weekend. They just rushed to the airport like that. And I think that first weekend sort of set the tone of people feeling like they have to be ready to engage at the drop of a hat very suddenly. There's not time to plan, long-term strategic litigation goals and how they can work together with, movement or an activist organization. It's just got to be a little bit sudden.
Mm-hmm. And that has to, as you said, it keeps everyone on their toes. But do you think that the administration was expecting that kind of response from the civil society as actually happened, or were they taken by surprise, do you think?
I'm not sure about the response from civil society. I think that the lawsuits certainly could not be a surprise, as obviously after the election we announced, as did other groups, that we would be going to court over the, and we specified in what we said, we highlighted particular campaign promises that we thought might be implemented, which would be unconstitutional. But I think the volume of litigation has perhaps been a surprise, that the involvement of states and localities. So I briefly mentioned Hawaii v. Trump, one of the travel ban cases. That's not the only one. There's litigation over funding for so-called sanctuary cities, when you have states and localities that want to protect their immigrant populations and take certain measures within their own power, who are now being threatened with the loss of federal government funds. And so there's been a lot of federal, state, and local litigation as well, which again goes along with all of the efforts of civil society. So there's a lot going on in the courts.
But you saw quite early, the ACLU saw quite early on, because even before he was elected president, the campaign was see you in court. But still, it takes a lot of time, effort, money to go through courts to change this, to change laws and everything, or rather to not to change law, but to, I can't find the word, but to have it, to challenge the laws, or the executive orders. Is the support you get? I'm guessing that the ACLU received a lot of new supporters and supports, and also perhaps Center for Constitutional Rights and other organizations that work through lawsuits. How was it with the ACLU? What was the response from the public to your see you in court? Because it is a little bit provocative in a sense.
So that, I think, has been a surprise to me, at least personally, but a wonderful outpouring of support. The weekend of the first travel ban in January, we raised more money online, I think, than we've ever raised online, and meaning not from institutional donors or just people who were so upset who went on our website and gave money. And I think that first weekend was when we first realized that this is going to be a big thing, and that people are very engaged. They want to see these challenges. They want to engage in activism and call their elected officials and push, but at the same time, they want to make sure that these policies are being challenged in court. And I think that's the reason that they are supporting us. So that, I think, was a very much needed push at the beginning of the year, at the beginning of the administration, and also just really reassuring. And I think, as I mentioned, a lot of these policies we've been challenging through past administrations, including the Obama administration. We've been doing a lot of these things for a while, and often without a lot of attention and focus on it. And I think, particularly during the Obama administration, there may have been less of a focus on the work. So now, all of a sudden, to have all this attention on these issues, I think it's also an opportunity for us to talk about things that maybe people weren't engaged in before. So things like immigration detention or national security policy, there's now a new attention on us and our work because of the Trump effect. But I think it's an opportunity for us to talk about the human rights work that we do writ large.
There's a question over there, if anyone can help out with the mic. Is there anyone? Before Shan asks that question, can you say, because from what you tell us, there seems to be quite clear that the Trump administration is targeting particular people. Who would you say? I mean, because is it, who would, I leave it to you to try and explain, because it's not really, who is it not targeting? Or is it, because the Muslims is quite clear, he wants to keep them out of the country, more or less. Women's rights, the abortion, who else is in line of his
I think the immigrant community has been a very large focus of the administration. And I'll give an example, a couple of other examples of policies that haven't been challenged in court, but they nonetheless, I think, are indicative. So, one is the president signed an executive order in January. It was the border wall executive order, which got a lot of attention. But within that executive order, he also stripped certain privacy protections from people who are not permanent residents or citizens. These were statutory protections that had long been given to non-citizens, to everyone. Data privacy issues, which I know in the EU there's a different data privacy regime. And in this executive order, said that the federal government will no longer provide those privacy protections to the information of non-citizens. And we strenuously objected to that, because there's there are privacy rights at stake. You've got a lot of people who are the victims of crime, domestic violence. Their information is held by the government. People applying for asylum, whose information, if it's not protected and gets out into the world, can be very dangerous for them, including in the countries that they've come from. So, you know, I think that's been one example of just the targeting of the immigrant community. Of course, then we've seen other actions like rescinding DACA, the protections for undocumented immigrants who are brought to the States as children. So, you know, that's been a community that's really been, I think, under siege this year.
Yeah. And how many do you estimate are in the United States undocumented?
I think the current estimates are around 12 million.
So 12 million people.
Yeah, and 12 million people and their families and friends and employers and communities that, you know, is all affected by this.
I will return with a question, but I'll leave the floor to a question to the audience. Can you tell us your name and question, please?
My name is Nanny Fredriksson. I have two questions. The first one is if you could fairly briefly explain impeachment and the procedure for that, because every so often articles pop up that say, okay, now we have enough for impeachment, or now we're preparing it, we're getting very close. And I would like to just hear a little bit more about that procedure.
Sorry,
the second...
sorry, I didn't catch the first part before the mic cut in.
Oh, sorry.
Which procedure?
For impeachment, to impeach
I
President
see.
Trump. Because every so often here in Sweden, it pops up articles or, you know, posts that now we're closed, now we have enough, and so forth. I would like to hear a little bit about that. My second question is something that really worries me. His way of acting in social media, for example, tweeting and being very active, as somebody here said, the Trump effect, could work as a diversion from what's actually going on, quote, behind the scenes. From friends in the States, I've heard that there are plans for cutting benefits for public schools, cutting back on support for people with disabilities and so forth. And the diversion of his way of acting, meaning that the public is not aware of so much going on. And is there a big risk that this will come to knowledge too late to be challenged, these kind of decisions? That's my question. I'm sure there are many more examples of that.
Great, thank you. So I think your two questions, I'll take them in turn. And the first one on impeachment, that's led by the political branches. It's not something where a civil society group can go into court or take on the initiative, and that really is something that's in the hands of Congress. They control, you know, the process of doing that, and both the House and the Senate are involved. On the second question of social media and distraction, I think that actually is a nice segue, I think, to talk a little bit about freedom of expression issues in the US, which is the issue that I primarily work on. And we've had a lot of debate this last year about social media, the use of social media, both by the president, but also by you know, a wide variety of groups. The issue of harassment on social media, but also from the government side, the issue of national security implications of social media use, and all of these concerns have been raised from various angles. At the ACLU, our concern primarily is, is in promoting freedom of expression principles. So the first critical thing is social media companies are not covered by the First Amendment in the way that government is. So the First Amendment protects us against censorship by the government. And so, oftentimes we are asked, well, if a social media company takes down my post that is critical of the government, doesn't the First Amendment protect me? But the First Amendment is not a protection against that. Nonetheless, our concern is very much that when you have large social media companies that in effect control what now serves as the public square, that the pressures on them from government to censor or take things down will lead to really silencing minority voices, will lead to a culture of censorship or overprotection on the part of social media companies, where they'll feel that pressure, they'll take down dissident voices and dissident views because they won't want to deal with those marginal issues. Which I think, it doesn't quite answer your question about the use of social media and the distracting function of that, which I think, I think that goes to people's sort of personal preferences, right? Some people, I think, are happy that we in fact see what the president is thinking and doing, and some people would rather focus on other things. I will notice one interesting thing that has been happening this year is that the president's tweets have come up in court cases, and we've even seen judges citing the tweets as evidence of motivation, because as I mentioned, with the travel ban and with the ban on transgender individuals serving in the military, motivation is a key part of those cases, whether there was an impermissible government motive. And so we're now seeing the tweets and the public statements being cited.
So he's actually giving the motive to the courts himself. I wanted to ask a little bit more about the Jane Doe case. If to put that in context, what in the U.S., if you were to describe the right to abortion, how would it? What is it like? Is there a right to free abortion or not? And in different states, of course, as well.
So we have the decision in Roe v. Wade, which essentially said that the government cannot prevent women from getting an abortion. And that decision was subsequently, the standard was articulated in a subsequent case known as Planned Parenthood v. Casey. So in effect, the rule is that the government cannot place an undue burden on a woman getting an abortion. And most recently, in a recent Supreme Court case, the government has tried at various times, various states have tried to regulate abortion clinics, imposing requirements like the size of the hallway or how big the building has to be, requirements that have nothing to do with, the procedure or are not medically necessary. And the Supreme Court said, those sorts of requirements are impermissible because they do impose an undue burden. They will force clinics out of business. So it's not just physically preventing women. It's also these other types of burdens that the government can impose. Nonetheless, there isn't a right to government-funded reproductive care, abortion care, and in many states there have been battles over insurance coverage, including private insurance coverage. So the right, I think, is best characterized as it stands as a limitation on what the government can do to prohibit a woman or a person from getting an abortion, but it's not an affirmative entitlement to funding or to support, and so that's why we see the burden falling disproportionately on poorer individuals, people who live in rural areas who may not have access to medical care in the same way, and that was one of the critical questions in the Texas case involving clinic regulations, where you had women who would have to drive hundreds of miles to get to their nearest clinic, especially as clinics were shutting down and making it more and more difficult if you live in a rural area to get access. So access is a real concern.
And the latest I heard from when it comes to the Jane Doe case was that the Ministry of Justice has now tried to get the case to the Supreme Court and is targeting the ACLU lawyers because saying that you prevented them from you didn't tell the government that Jane Doe was getting the abortion, so they couldn't take the case further because the abortion had already happened. And now they say that they will target the individual lawyers of the ACLU. Do you see this kind of war against you as because from our point of view it seems that this was just the beginning of a bigger war against the opponents of the Trump administration's politics, including their organization, or how has that been received within your organization?
So yes, we will certainly respond in court, to the allegations that they made that are baseless. But I think there's a larger message that's being sent, and I think the larger message is about civil society and civil society lawyers who are opposing the administration, which is something that, as I mentioned, we have long done with every administration. So I hope that the message isn't you should be deterred from litigating these things. There's a lot of lawyers doing a lot of these cases, not just at the ACLU, as I mentioned, and a lot of them maybe don't come from a big organization or have resources. And so the concern really is, are these lawyers going to be deterred from bringing cases? And I really sincerely hope not, because we do need, members of the profession, who don't do this necessarily for a living, but who might do cases pro bono, for example, who might support in areas of the country where there's not a lot of legal services, who might be able to give their services and donate their time. So we need more than just the ACLU lawyers and the civil society lawyers to be willing to take on these cases.
Okay. So that will actually be the final word for this session. Thank you so much, Esha, for being here. Very interesting to hear.